Thank you very much. I really appreciate greatly the hospitality I've gotten from both professors here, and so I really appreciate it. And I'm going to be talking, as I said, place for neuroscience and criminal law. I'm going to be talking about a study that I've been doing for the past several years on 800 criminal cases that span the course of 2 decades, from 1992 to 2012. I'm still continuing to analyze this data set, and I have about 5 or 6 publications from it, and I'm also working on a book. So because of the number of cases, and each case is about 60 pages long, I have a lot to work with, and doing a lot of research on it. So let me get started on looking at this. And essentially what this is about. I mean, essentially when you start looking at the impact of neuroscience in the criminal law, sort of a standard case would be like the case of John McCluskey. And in the United States, so many of these cases are driven by the fact that we have a death penalty. And of course, that's foreign to you all, but it's a driving force in our criminal justice system, and it's a key font and source of the use of this neuroscience evidence, and it's used differently in these kinds of cases than it would in the guilt or sentencing phase that would, say, be applicable to your cases. Nonetheless, it's also used in the guilt and sentencing phases as well, so it's not just death penalty cases, and the effect of this evidence in a death penalty case is trickling down to other parts of the criminal justice system. So John McCluskey, as many of these defendants are, was extremely violent. In 2010 he escaped from prison, and he ended up killing a couple who were retired on their vacation. They were in their camping trailer, and the crime was horrific, as many of these crimes are. He shot the couple who were defenseless in their trailer, and then set the trailer ablaze to hide the evidence. Nonetheless, there was expert evidence introduced in this case to determine whether or not he was going to get the death penalty, not whether or not he would be acquitted. I mean, it was clear that he would get life in prison, but certainly the question was whether or not he was going to be executed. And the expert evidence, and the jury seemed to be influenced by this evidence, was indicating that McCluskey had substantial frontal lobe damage, and in the jury's view, and the jury was interviewed after this case, his brain abnormalities were a mitigating factor that decreased his level of culpability, and according to the expert, his ability to plan or intend the kind of crime for which he was being sentenced to death. So he's certainly in prison for the rest of his life, but he's not going to be executed. So that's sort of the classic way that this evidence would be used, if in fact it's going to be used at all. It was also, of course, not the only evidence in this trial. Was just simply validating a lot of other evidence that was introduced. In all these death penalty cases, you have an enormous amount of evidence. So everybody focuses on the brain scans when in fact you have a lot of other kinds of history evidence about somebody's background as well. In the case of Grady Nelson, also in 2010, who was convicted of first-degree murder, and really, again, another horrible crime, convicted for murdering many of his family members. This was a case that was pronounced because it was the first case in which brain mapping evidence was ruled admissible for the first time, and that seemed to also have an influence on whether or not he was going to get the death penalty. And again, this is a case where the jurors seem to be influenced by this evidence. Of course, it's hard to tell, I'm just picking out 2 cases where it happened to be influential and where jurors were interviewed. But this certainly is not always the case, and in fact, it's hard to tell when that's the case, because there's so much other evidence that's introduced in these death penalty cases, particularly about somebody's background. So I was, having gone to a lot of different conferences on neuroscience and law, and having written about this for a long time in my past and for my PhD dissertation, I was finding that every time I went to a conference that the same 5 or 6 cases were being discussed, and not always real criminal cases like the Charles Whitman Texas Tower case. He seems to be brought up all the time, but he wasn't actually even a criminal defendant. He was shot at the time of the scene. He had gotten into the Texas Tower at the University of Texas and had killed several people, but he was shot the moment soon after he did this, and he had a brain tumor, but nonetheless people keep on talking about this case that is decades old. So I really was motivated to look at what exactly the criminal justice system is doing. I mean, what's this evidence looking like? Because there were so many distortions and assumptions of what it would do without anybody really looking and seeing for the facts. So the rising acceptance of neuroscience evidence has started to fuel a debate on its impact on the criminal justice system. But of course, the criminal law is focused on the human mind and mental state since the 17th century. We've always had some concept of mitigation in the criminal law, and it's not just the United States, but of course in Europe as well. I mean, that started in early history with the devil, and then has just moved on with the Renaissance and different ways of explaining the human mind. So I see this, the introduction of neuroscience is just a continuation of other kinds of evidence that's always been introduced into the criminal justice system, and to explain why people do what they do, and particularly as a issue of mitigation. So you can define neurosciences in many different ways, and I took in this study a very broad perspective. I thought I could always whittle it down in collecting cases and get to a more specific definition. So I started with a very broad definition of the branch of life sciences that studies the brain and neuroscience, including brain processes such as sensation, perception, learning, memory, and movement. So that's incredibly broad. But I wanted to focus in particular on cognitive neuroscience and the specific mechanisms of the mind. So in looking at this study, one thing that I derived from it right away is that this evidence is fully accepted by the criminal justice system, at least in the United States. It's ingrained and incorporated and accepted by the criminal justice system. That doesn't mean that it's not controversial, that it's not attempts to keep it out of court, particularly by prosecutors. But this was at least initially a surprise to me because of the conferences I had been going to. A lot of people would always talk about when it's introduced in the criminal justice system, but it's been accepted. It's a stable component of the criminal justice system, whether we like it or not, and has been for a long time in the cases that I've been looking at. So of course this fits in with the criminal law, because key criminal law concepts of culpability depend on the internal workings of individuals' minds. So it doesn't seem a stretch that you would be looking at this kind of at this kind of evidence. Nonetheless, there is a bias in looking at this evidence, or has been, before people have looked at it. And the bias goes like this. And there's a concern, and it's certainly, at least in the United States, particularly in newspaper clippings or publicity about criminal cases, that once you start introducing any kind of neuroscience evidence, that it's going to get people off completely. So the bias is that people just get acquitted from the criminal justice system and just to go on to kill again. And so that's one bias, when in fact that's not what's happening. They're simply not being executed, but they're retained in the criminal justice system usually for life. So it's not that they're being totally acquitted, even though that is a bias, and that sort of this. Oftentimes you'll see a headline like my genes made me do it, or my brain made me do it, and the concern is that people are going to get acquitted entirely, and that's not the case. But the contrary concern that's been raised, at least at the conferences that I was going to, if people aren't totally acquitted, the other concern is that this is going to be used to predict future dangerousness, and that juries are going to punish these people more as a result of this. So these are the kinds of questions that I was looking at. Is in fact that true? Is in fact how that evidence is being used? And I found, as a result, that it's really not being used this way. First of all, the great majority of neuroscience evidence is introduced into court by defense attorneys. For the most part, prosecutors are trying to keep it out. The reason is that it's viewed as mitigating rather than as aggravating, even though in some cases it is aggravating, and I'll talk about those cases, but for the most part it's viewed as mitigating evidence, and prosecutors want to keep it out. As I'll be talking about, there are some cases where it's used to predict future dangerousness for a defendant, but that's typically because defense attorneys aren't doing a very good job. It's their expert that is that's talking about future dangerousness in a way that suggests that the attorneys simply aren't prepping them properly, rather than this being a knee-jerk reaction in the way that it would typically be used. So, so just to talk about the study a little bit, it's an analysis of all criminal cases. It was 800 cases addressing neuroscience evidence between 1992 and 2012. As I said, I looked at a very broad definition of neuroscience. I got the cases from databases in the United States that you all may use. I'm not quite sure, like Lexis and Westlaw. That's okay. And as you know, there's no head note for Lexis and Westlaw and saying neuroscience. It's a definition that I had to come up with on my own. I had whittled it down from 800 cases, but I started with 15,000 cases, because when you start looking at the terms that I was looking at, it gets so much. These databases aren't always perfect, so I had to my assistants and I had to actually go through these cases by hand and screen out the ones that weren't civil cases or that weren't cases that were occurring in prisons or things like that weren't applicable. As I said, every case is about 60 pages long, so they're pretty intricate. We coded each case for up to about 120 variables, but every time I've done a study or done a particular topic, I recode for those. So I've done 6 articles already, and I have to recode depending on the particular topic I'm looking at. So it's a systematic empirical database that shows how neuroscience evidence is actually used in courtrooms, and I was interested in that as well. There have been excellent hypothetical studies that have been done that again I think are very good, but I really actually wanted to see how it's being treated by in actual criminal cases, because these cases are very complex. And so sometimes hypotheticals are very helpful, but they can simplify things a little bit in a way that they really aren't. So as I said, neuroscience evidence has been integrated into the criminal justice system ways that have not been documented. And the first finding is that the system is willing to accept and comprehend the strengths and limitations of these evidence and to discredit what I call this double-edged sword concept. So the key question is not whether neuroscience evidence should be used in the criminal justice system. It's being used. Whether we think that's right or whether we think it's used well, or whether we like this or not, it's definitely being used in the criminal justice system, and that's increasing all the time, as you can understand, particularly with defense attorneys wanting to use this. So the question is not whether it should be used, but rather how it's being used and why it's being used. So I had this broad definition of what constitutes neuroscience evidence, but I had to operationalize that and get much more specific when I was actually looking at the kinds of testing cases that I was considering. So I have 2 broad groups of tests. Number 1 are these imaging tests generated by computer images of a human brain. This is MRI and PET scan and your regular sort of standard tests, but also non-imaging tests that are administered by a medical professional to an individual. There have been other people who've done this kind of testing, but I was, or or started to look at criminal cases as well. But I was also, not everybody's incorporated non-imaging tests. I thought that was very important because more non-imaging tests are used in these cases than our imaging tests. Everybody focuses on the imaging tests, but it's important to remind people that at least for me, that non-imaging tests are being used, and they have been for decades. So again, just a reminder that this is not really something new so much as a new type of testing, but non-imaging tests have been used particularly in all sorts of criminal cases for decades. And that the brain scans are just yet one more group of tests being used in addition to the non-imaging tests. Every time I talk about imaging tests in this talk, there are also been applied non-imaging tests. So the best way, of course, to look at any kind of brain damage or anything would be to look at a variety of tests, not just focusing on certain types. In my database of 800 people, I had 514 were defendants, 247 were victims. One thing that I learned right away when you start looking at neuroscience in the context of these cases is, of course, about a third of these cases are involving victims, and the brain scans done on them. And a number of people don't look at victims when they're analyzing these cases. I think it's critically important to look at victims. In this talk, I'm only going to be looking at defendants, but I've written a couple articles on victims, and how that works is you look at the brain damage, or in these criminal cases, courts consider the brain damage of the victim in a way to determine the defendant's mental state. So it's almost 2 steps removed from determining mens rea, or a defendant's mental state. Where a lot of those cases occur are in shaken baby cases, which I know is controversial in Europe as well. These are cases where the manner in which the victim is injured, or by the manner in which they died, those brain scans are used to determine the defendant's level of intent. And in the United States anyway, there have been, and in my data set, a number of first-degree murder convictions based on shaken baby syndrome evidence, which is a highly controversial use of brain scans. And as I said, I've focused on those cases. They're very troubling, and a number of those cases are being overturned in the United States because the science is so bad. But you have people who've been in prison for 2 decades based on these kinds of convictions. Again, I'm not talking about that today, but I just wanted to mention that I have looked at victim cases, and I find them very troubling, particularly troubling in many ways. So I'm just going to be looking at 553 defendant cases where the claim is that there was something wrong with the defendant. In these cases, the great majority of these cases, as I said, are capital cases. They start as death penalty cases. Other cases are life, or life without the possibility of parole, working on down to other kinds of sentences. In some cases, the sentence is not yet given. Those are in death penalty cases that can go on for years sometimes, or other kinds of cases where it can take somebody a long time to get a sentence. But most of these, the great majority of these cases were involving long sentences, and the great majority of these cases were murder cases. In death penalty cases in the United States, you could spend a lot of money on death penalty cases, so this is where you could afford to do a lot of scanning, a lot of testing, both imaging and non-imaging tests. So, what the study reveals is that this evidence is used in the capital cases, but it can be used both in the guilt or sentencing phase. I've looked at all sorts of defenses now that are being used in these cases. I'm in the process of writing that information up. Diminished capacity, insanity, self-defense in one case, neuroscience evidence used in a case where the defendant had dementia. But they're also used, as I said, in the penalty phase. In the penalty phase, in a capital case, it's used either for aggravation or mitigation. As I said, for neuroscience evidence, it's typically always used for mitigation. But in a capital case, the prosecution brings in aggravating factors, the defense brings in mitigating factors, and the battle begins over what's going to happen in these cases. Just in looking at the neuroscience evidence here for the kind of evidence that was brought in, I was surprised to see how much of this evidence is used to support a claim that the defendant was under the influence of drugs. Sometimes when that kind of argument is being made, it's because that defendant has brain damage as a result of drug use, that it has created brain damage, and there's evidence of that. So that they have some sort of frontal lobe damage, depression, organic brain damage, mental retardation, et cetera. In the United States, you can't be executed if you have an IQ, low IQ less than 70, and other kinds of factors. That's relatively recent. Until recently, we had no problem executing those people. In other kinds of cases, just generic categories, it was for brain damage or any kind of head injury. As you can imagine, many of these people have extensive head injury that's existent since they were even very young. In some of these cases, it's brought in cases of malingering. I'm having a symposium at Fordham on the future of neuroscience evidence. I'm going to have a whole panel on malingering because so many of these cases are about courts being concerned that the defendants are feigning their mental illness or their brain damage. And one advantage of actually having brain scans is that defense attorneys can more easily argue that this isn't something that's made up. It's that you could bring in scans showing that there's actual brain damage. Whether or not the courts accept it as well is a different kind of question. You can see the different kinds of scans that are used, mostly CAT scans or MRIs. Some cases EEG. I found disproportionately that EEGs are used in insanity defense cases. I don't think that's I think that's because of a lack of funding as opposed to, or maybe a lack of sophistication in some of these cases. PET scans, SPECT scans, you could see QEEG that was just recently, as I said, first introduced in criminal cases in the United States in 2010, but you could already see it being used in these cases. Also, you could see the kinds of non-imaging tests that are used, the WAIS, the MMPI, Bender-Gestalt, Rorschach, many different kinds of non-imaging tests. I'm just presenting the ones that are used most frequently. You could see the test of memory malingering that's also being used. Of course, we do see that some of these people are lying or malingering, but oftentimes they're not. What I was particularly interested in is starting in 2009, the United States Supreme Court in a series of cases held that in capital cases, that defense attorneys have an obligation to start introducing into court evidence that is mitigating, that attorneys must investigate all reasonably available mitigating evidence. This isn't a choice. In other words, that is an obligation that attorneys have. These are called Strickland. This is a case of Strickland v. Washington, and that if attorneys don't do this, they can be rendered ineffective. It's very hard to prove that somebody's ineffective in a capital case. They can be drunk, they can be asleep, they can, in one case, an attorney, his son, who was in high school, did the closing arguments of that case because the attorney just knew that he was losing and he was just so upset he wasn't rendered ineffective. So these are very hard to prove. It's just about 1% to 3% of any capital cases proved to be ineffective. Starting in 2009, the United States Supreme Court held that attorneys must investigate all reasonably available mitigating evidence, and that included evidence of brain cognitive dysfunction, and they gave that as actual examples of organic brain dysfunction, et cetera. This includes defendants' cognitive and intellectual deficiencies, and the court, in a series of cases, concluded that this evidence has a pronounced impact on mitigation, particularly in capital cases. So again, whether or not you think this evidence should be introduced in court, the United States Supreme Court has made clear that attorneys have an obligation, at least in capital cases. So this is a two-pronged test. Counsel's performance has to be deficient as a result of this, and the deficiency has to prejudice the defendant. So maybe you have something similar, and I'm sure you do in Europe, but it's so I was finding that, oftentimes in capital cases you bring a number of ineffective assistance of attorney claims, say up to a dozen in one case. If there was a case where, if any of these cases, at least in my data set, included a claim that the attorney should have introduced neuroscience evidence and they didn't, or they did introduce it in a case and they didn't do it well, in other words, they didn't use the right kind of expert, or they did a bad job with it, they made the wrong kind of argument, that was very influential in determining whether or not an attorney was found to be ineffective. So the type of relief that was typically granted in these cases was that there was a new penalty phase, the case was reversed, in other words, the conviction was reversed and a new trial was granted, or was remanded with instructions to hold a new evidentiary hearing. So this was the outcome. So in other words, not introducing neuroscience evidence or doing a bad job of it seemed to be an influential factor in determining whether or not an attorney was rendered ineffective. So among the Strickland claims that was recorded in the 553 defendant cases, nearly all of the successful claims are based on an attorney's failure to appropriately investigate, gather, or understand neuroscience evidence. So this is the court's statement, in other words, that they considered this information to be important and that attorneys have an obligation to introduce it. So how do counsel damage their cases if this is what's going on? They do it in two different ways. Some do it actively and some do it passively. An active way of damaging a case is using an expert who's the wrong kind of expert, who's testifying and using neuroscience evidence in a way that's going to be very negative for the defendant. That's either because the defense attorney didn't give them enough guidance, or they didn't prep them sufficiently, or introducing or not using the right test. So I have cases where they're using neuroscience evidence to argue for intoxication, either alcohol intoxication, when in fact they should have argued for diminished capacity, or they should have argued for insanity or something like that. These are attorneys who really don't know what they're doing. Something more passive would be not to introduce evidence whatsoever. And the reason attorneys say this is that it's a strategic decision not to introduce the evidence. There is some evidence that their client was brain damaged or had some sort of problem, either organic brain damage, or that they were mentally retarded, or they had some sort of neuroscience disorder. And the primary strategic reason attorneys say is they think the evidence is going to do their client more harm than good. And that it's going to be more negative than it would be positive, and that a jury is going to take this evidence and think that this person is going to be a future danger, or they're just going to do it again. But the reason these attorneys would be found ineffective, however, is that in so many of the cases, this evidence is considered to be mitigating, number one. And number two, in order to make a strategic decision, you have to investigate and analyze this information first. In a lot of these cases, the attorney didn't do that. In other words, they said, I made a decision not to introduce evidence that my client has had a long history of brain injury and brain damage, but they never actually investigated it. They never did the homework they were supposed to do in order to be able to make that kind of assessment. So other attorneys say the sentencing phase was unexpected, so that they didn't expect their client to get the death penalty. Ignorance or mishandling of evidence or in communication with experts or clients. In some cases, the attorneys didn't, it was just incompetence. Or as I said, the belief that neuroscience evidence would do more harm than good. So I've looked at a number of cases where courts reject this strategic decision. So example, in the Hearst case, counsel failed to investigate or present any kind of mental mitigation evidence, claiming it would be inconsistent with the client's innocence. In other words, they were claiming their client's innocence. But in the Hearst case, this is evidence of somebody had lifelong problems with brain damage. And a lot of testing. In other words, in many of these clients' cases, they have school records showing that this person was beaten by their parents, that they had their school records of some kind of brain disorder or something like that. So a lot of this is counsel simply not doing the kind of homework that they're expected to do to investigate the client's history. So what do courts expect from attorneys using neuroscience? If in fact they can be found ineffective if they don't use it, what do they expect? And why are these cases deemed ineffective? And so basically in these case studies, what courts are saying is just simply go and investigate this, do a prior case history of the defendant, go back to their school records. If there's been any kind of testing done, and it seems to be relevant and could be mitigating, then at least consider it. In the Frierson case, for example, again, it's another case where the client had a long history of mental illness, schizophrenia, depression, bipolar disorder, and again, a history of brain injury, where the attorney never even bothered to take the time to look at that kind of evidence. In the Hooper v. Mullen case, that was a case involving an attorney who was interviewing the expert who never had a chance actually to even look at his client and to interview his client. And the expert said to the attorney, "Don't introduce me in court because I never even had a chance to look at your client, and I would have to say that." And the attorney introduced him into court anyway. And the judge ended up holding in that case that the attorney had done such a bad job on behalf of his client that he did more harm than good, and more harm than even a prosecutor would have done in arguing that this client should get the death penalty. So I have a number of cases like that. So essentially in these claims, it's critical for attorneys to fully investigate and present mitigation evidence, particularly in death penalty cases, and that neuroscience is an important component of mitigation. So then the next question I had was, again, because it was given so much as an excuse by attorneys, is it really a strategic decision not to introduce this evidence because there's a likelihood that the defendant will commit a future crime? Is that a real concern? Because this kind of aggravating evidence can be introduced in every death penalty case in the United States. In other words, there's an opening for this kind of aggravating evidence that this person would be a future danger. In the past, this has always been based on psychiatric testimony. And there have been really horrible cases in Texas of a psychiatrist that dominated for decades a number of those cases because he always claimed that this person was going to be a future danger and that he would kill again. So is this a real concern? And I found out it really isn't. For the most part, prosecutors don't want this evidence in at all because it's going to typically be viewed as mitigating. And if a prosecutor in a capital case raises concerns regarding a defendant's future dangerousness, the jury must also be instructed that life in prison is equivalent to life without the possibility of parole. And if juries are given that instruction, that it means that they're far less likely to, they'll be far less likely to choose a death over life in that kind of case. So a prosecutor has to face the likelihood also that somebody's going to be given that instruction, and that's a really powerful instruction. So if a prosecutor is trying to get somebody the death penalty, then this is all the more reason not to argue for future dangerousness, nor to use neuroscience evidence in this kind of context. So this doesn't mean that prosecutors don't argue for future dangerousness. It just means that, at least in my research, they're not using neuroscience evidence to make that kind of argument. Nor has, and Francis can add, correct me on this, but the latest information I have on this is that, and I'm always looking for this, is there's never been an expert who's been introduced in a death penalty case in the United States who's ever testified using neuroscience evidence that someone's ever going to be a future danger. That doesn't mean that this might take place at some point in the future, but it certainly hasn't yet. And somebody would have to have very good predictive abilities. So I found that in my 553 cases, that less than a dozen cases were cases that were used to argue, where the neuroscience was used by a prosecutor to argue that this person was going to be a future danger. But in nearly all of these cases, it's because that evidence was brought in by a defense attorney and just not using the expert in a very good way. In other words, the expert, at least in one of the cases where a prosecutor used this the most, the expert would say, this is the defense expert would say, this person's going to be a problem in the future, or I don't know what this person's future is going to look like, in which case a prosecutor would use the evidence introduced by the defense to argue that this person is going to be a future danger. So I have a number of cases where that's happening, where it's really because of the defense not doing a very good job. They're the ones who are introducing this evidence, and a prosecutor just jumping on it and using that in a very negative way. But the defense attorney's not bad enough to be rendered ineffective. This is clearly an error on the part of the defense attorney, but given how hard it is to find these attorneys ineffective, even though it's widely recognized that they did a very bad job with their expert, they're not bad enough to be rendered ineffective. So in the Farley case, for example, the court found that counsel was aware that the nature of any mental disorder or behavior problem would be explored in detail, including any persistent and continuing patterns of violent conduct. In other kinds of cases, such as Farley, the court accepted the attorney's explanation that they thought this evidence would do more harm than good. But in the Farley case, the dissent just said that's not true at all. This could have saved somebody's life. It could have well been considered mitigating evidence. Same thing with the Bryan v. Mullen case. Counsel said that they lacked medical evidence necessary to adequately argue an insanity plea. The defense said that's not the case as well. Of course, this is a case where the defendant didn't want anybody to argue that he was insane, as most defendants don't. But anyway, these are cases that all, if you start looking at the details, there are reasons why you could figure out why this could be used as a prosecution to argue that this person would be a future danger. But again, this was only in about 10 of these cases out of 553 that I was looking at. So just to end up here, to finish up, courts urge attorneys to fully investigate and present mitigating evidence, such as neuroscience evidence. That, as I said, the United States Supreme Court expects attorneys to do this. Yet in a limited number of cases, courts also accept arguments that neuroscience evidence can be indicative of a defendant's future dangerousness. I just wanted to make it clear that it is used in some cases to argue future dangerousness. That's in these cases, however, it's because a defense attorney has done a poor job. They've made mistakes. They haven't prepped their experts well enough, and they end up introducing evidence in a way that's very negative for their clients. Or they argue that it was a strategic decision not to introduce this evidence, even though there are pretty powerful dissents in this case indicating otherwise. So just as a conclusion, the criminal justice system accepts the strength and limitations of this evidence that discredit this sort of myth of a double-edged sword, that modern methods of assessing defendants' mental capabilities are, that this is expected. And as courts continue to support neuroscience tools, and they are, I mean, defense attorneys in the United States are rapidly and consistently trying to use more of this evidence. Empirical data will provide a foundation for discussing these cases. I end in 2012 because it's taken me so long to clean the data and to start analyzing it. But once I get a hold of it, I want to update everything up to the present time. But I have to get some analyze what I have so far to get a sense of what this data is saying. So. Anyway, any questions? Thank you. Thanks. Classic way that this evidence would be used, if in fact it's going to be used at all. It was also, of course, not the only evidence in this trial. Was just simply validating a lot of other evidence that was introduced in all these death penalty cases. You have an enormous amount of evidence. So everybody focuses on the brain scans when, in fact, you have a lot of other kinds of history evidence about somebody's background as well. In the case of Grady Nelson, also in 2010, who was convicted of first-degree murder, and really, again, another horrible crime, convicted for murdering many of his family members. This was a case that was pronounced because it was the first case in which whether or not he would be acquitted. I mean, it was clear that he would get life in prison, but certainly the question was whether or not he was going to be executed. And the expert evidence, and the jury seemed to be influenced by this evidence, was indicating that McCluskey had substantial frontal lobe damage, and in the jury's view, and the jury was interviewed after this case, his brain abnormalities were a mitigating factor that decreased his level of culpability, and according to the expert, his ability to plan or intend the kind of crime that for which he was being sentenced to death. So he's certainly in prison for the rest of his life, but he's not going to be executed. So that's sort of the clay, and essentially what this is about. I mean, essentially when you start looking at the impact of neuroscience in the criminal law, sort of a standard case would be like the case of John McCluskey. And in the United States, so many of these cases are driven by the fact that we have a death penalty, and of course that's foreign to you all, but it's a driving force in our criminal justice system, and it's a key font and source of the use of this neuroscience evidence, and it's used differently in these kinds of cases than it would in the guilt or sentencing phase that would, say, be applicable to your cases. Nonetheless, it's also used in the guilt and sentencing phases as well, so it's not just death penalty cases. And the effect of this evidence in a death penalty case is trickling down to other parts of the criminal justice system. So John McCluskey, as many of these defendants are, was extremely violent. He's in 2010 he escaped from prison, and he ended up killing a couple who were retired on their vacation. They were in their camping trailer, and the crime was horrific, as many of these crimes are. He shot the couple who were defenseless in their trailer and then set the trailer ablaze to hide the evidence. Nonetheless, there was expert evidence introduced in this case to determine whether or not he was going to get the death penalty. Thank you very much. I really appreciate greatly the hospitality I've gotten from both professors here, and so I really appreciate it. And I'm going to be talking, as I said, place for neuroscience and criminal law. I'm going to be talking about a study that I've been doing for the past several years on 800 criminal cases that span the course of 2 decades, from 1992 to 2012. I'm still continuing to analyze this data set, and I have about 5 or 6 publications from it, and I'm also working on a book. So because of the number of cases, and each case is about 60 pages long, I have a lot to work with, and doing a lot of research on it. So let me get started on looking at this.